I'm gonna have to take just a minute. Even with the door open, there's gonna be people walking through and I can hear voices, so.
I think they're all just getting welcomed in now, Senator.
Wendy, can you hear us?
I can hear you, yes. Can you hear me?
We can, yes.
Okay, great. Good morning.
We're just working through a little bit of technical difficulties here.
We ready? Can we please have the roll call?
Can you hear me?
We can barely hear you. You're just really quiet.
Can you hear me now?
Oh, it's still pretty quiet, Judy.
Maybe the volume on both the bottom right-hand corner and on the screen. The screen. The keyboard.
Do you want to try again, Judy?
Okay, if I shout, can you hear me?
I can do a roll call.
Okay.
Judy, I'm gonna go ahead and do the roll call if that's okay.
Okay.
Right. Governor Michelle Lujan Grisham, Lieutenant Governor Howie Morales, State Treasurer Laura Montoya,
Good morning and present.
Michael Sanchez,
Good morning, I'm here.
Paul Cassidy,
Good morning, present.
Joseph Lujan,
Present.
and Wendy Trevisani.
Present.
Do we have a motion for the approval of today's agenda?
So moved.
Second. We have a motion to approve by member Montoya, a second by member Cassidy. Would you please call the roll? Sorry.
Yes, and Judy, I'm gonna go ahead and do the roll call if that's all right as well. So, State Treasurer Laura Montoya,
Yes.
Member Joseph Lujan,
Yes.
Member Paul Cassidy,
Yes.
Member Wendy Trevisani,
Yes.
and Member Michael Sanchez.
Yes.
Right, the agenda is approved.
Thank you. Next item on the agenda is item number 3, the approval of the minutes from July 15th, 2025 regular meeting. I think we had a chance to review those. If it appears everybody has, we have a motion to approve the minutes of the July 15th, 2025 regular meeting. We have a motion by member Cassidy. Is there a second?
Second.
A second by member Lujan. Would you please call the roll?
Yes, Treasurer Laura Montoya,
Yes.
Member Joseph Lujan,
Yes.
Member Paul Cassidy,
Yes.
Member Wendy Trevisani,
Yes.
and Member Michael
Yes.
Sanchez.
Yes.
Great, the motion passes.
Thank you. We are here today on the emergency funding for the 11th Judicial District Attorney's request for approval of an emergency operating grant for fiscal year 26 budget shortfall of $3,800,000. As we all know, this is a continuation of the prior hearing. And so that, District Attorney, why don't you go ahead and begin?
Thank you very much. I'm Bernadine Martin. I'm the elected McKinley County District Attorney, and with me is Joanna Cox, attorney for this matter.
Is she your representative?
She's representing the office.
Yes, I am retained for
Why
her.
don't you identify yourself, please?
Johanna Cox, attorney here in New Mexico.
Please.
So we were here before, based on the defunding of the McKinley County DA's office and needing funds to continue operating as a state agency. McKinley County DA's office is a legitimate state agency, currently has no funding. There's been some discussion since the last meeting with regard to an MOU. I will defer to Ms. Cox to discuss that. DA from Farmington is also here, who's a party to these matters. And we're back to give basically an update of what has gone on and the status of the office since.
Thank you, Madam District Attorney. Would you like the attorney to speak first?
Yes.
Ms. Cox, please.
Thank you. Since the last meeting you guys had, the parties did participate in a mediation process. There was a intergovernmental agency MOU that has been circulated to address things through the end of September. So the overall challenges have not quite yet been rectified. But it does allow for funding of all staff positions and part of the contract attorney positions and expenses through September 26th. To get accomplished. There's a couple things on the procedure end, I believe, that still need to get addressed. I believe DFA still needs to approve it, and then there's some work to allow the funds to be dispersed in order for these bills, these expenses to be covered. There has not been a full resolution for the last, that's okay, for the remaining 10 months of the year. So after September 26th, we do not have a resolution to address the finances for Division 1 and Division 2 and how they will, how that will all work out. So that is still outstanding.
What are the finances that are left outstanding after September?
Technically, after September, after the intergovernmental MOU is satisfied, the salaries for the employees and the expenses that are not covered by the MOU transfer will remain outstanding. I believe there is a potential workaround for that. Mr. Fortner is here and he can kind of help address it. There's a way that we can get that portion of the budget covered with the appropriation that was given to Division 1. What is not quite resolved is how the contract attorneys are going to be functioning between the two offices and that sort of case of appropriation and assignment.
Thank you, Ms. Cox. Before the board goes on, I would suggest that we listen to Mr. Fortner, who's the district attorney from Farmington, and then questions or comments by the board. Mr. Fortner.
Yes, I'm Jack Fortner. I'm the district attorney for the 11th Judicial District, Division 1. And I would tell you first that I was given, and I say Division 1 was given the funding for Division 2, and was neither my preference or my request. But the fact is, the legislature and the governor signed the bill that gave us the funding to work with DA Martin. And the way the funding was originally intended would be that all the employees of Division 2 would actually become employees of Division 1. And so that the employees of Division 2 would not lose their seniority or have to go back on probation. We then presented to the personnel board of the district attorneys, the ALDA, and all the DAs for a waiver. But it was before July 1st when the transfer was supposed to happen, so they did not do that at that time. Ms. DA Martin and I had a number of correspondence back and forth through email on where basically I was asking for cooperation to see how this would work, because it won't work unless DA Martin would actually assign cases to our office or to our lawyers, so to speak. As part of that, we had a lawyer in Gallup who was prepared to start working under that agreement. And former Judge George Harrison, who was a district judge, prepared to do work. And then one of my senior lawyers. And then Representative Annie Reeb, who also submitted a response to our RFP. So we were prepared to do that. In fact, myself, my office manager, my HR, and two of the lawyers actually met with DA Martin in Gallup to talk about the transition. At that time, there was a case before the New Mexico Supreme Court where DA Martin had filed a writ of mandamus. And at that point, DA Martin and I discussed what was to do next, waiting to see what would happen when the Supreme Court decided. The very next day, the Supreme Court denied the writ. And then the following day, a 12 to 14 page complaint was filed in the Santa Fe District Court asking again for certain relief. It's my opinion that no matter what happens in the district court, no court has the authority or the ability to re-legislate funds. They're not going to tell me. I mean, I wish they would tell one of us for me to either give her the funds or for her to cooperate, but I don't think any court is going to do that. And so what is required, there's no lack of funding. The funding's there, but it does require cooperation between DA Martin's office and my office. Now, up until this board had suggested we go to mediation, and we went to mediation with a very well-versed mediator by the name of Denise Torres. She used to be with the Marlboro Forum. I think she's a solo now, but I'm not sure. And we spent about 5 hours with her, and then we didn't quite reach an agreement. And then a couple days later, we did a mediation where we reached a tentative agreement. And then that agreement that Ms. Cox was referring to was signed by DA Martin over the weekend. And that provides funding until the end of September. And so I believe that, you know, who knows what the Attorney General is going to do. They say he's going to file something. He may or may not. You may know that the governor's office sent Attorney General a letter saying, would you please take action to remove DA Martin if she does not cooperate, because these cases will not be handled. And it's our opinion that based upon things that we've been presented, that cases are not being handled appropriately, which means there really should be funding. That DA Martin and I really should reach an agreement on how to do this. I met with the city attorney and the chief of police of Gallup, and they gave me a list of about 70 cases that they asked if I could start handling them right away. And I said, no, I can't do that. It doesn't work that way. DA Martin has to cooperate. Okay. The juvenile probation office, the head of that office oversees San Juan County and McKinley County. I would not give you those names, but there are 48 cases they have asked me to file that they've referred to DA Martin that she has not filed, and I believe some of them, the statute has expired. Madam Montoya, Madam Treasurer, you asked at the last hearing if there were cases that had been dismissed, and in response, DA Martin said to you, yes, in March, when in fact she was not totally forthcoming, because on July 3rd, there were actually 7 cases that were dismissed from the magistrate court that for her failure to appear. The 8th case was simply continued. I have that list here. I have those lists of those cases. The next thing that I have is, despite not having the funding, DA Martin has still assigned cases to Johanna Cox to prosecute. She doesn't have funding. And so we were sent the bill, but at this point, Ms. Cox has not done an RFP to us. And so we couldn't pay those. And so I believe that's in violation of the procurement code. And there are about 20 or 30 cases of this invoice of cases that happened after July 1st with new funding that has not they've not been paid because one, they were done because DA Martin basically hired her with no funding. The hiring based upon the funding should have gone through our office. It didn't happen. Now,
Mr. Portner, at this point, I appreciate the
history. Yes.
I think we're really here to decide whether or not there's an emergency. Those matters that you speak of, I think, are before the courts.
Yes.
And other entities, and I don't know, I've stated before, I don't know why it's before the board to begin with.
Yeah.
I have my misgivings about it being here in
Right. So
the
then,
first place.
in that case,
I understand the history.
right.
And again, we're here to determine whether or not there is an emergency in terms of paying individuals to work for the district attorney's office and making sure they're getting paid. We're kind of cross that.
Thank you,
in terms
Judge.
of what you
Thank
said,
you,
and
Senator.
I appreciate what you said, and maybe that's for another day before
Okay.
a legislative committee or for the courts. But I don't know that that is relevant to what we need to be deciding today in terms of what is being asked for. And so if you don't mind, and I'm sorry to interrupt.
That's okay.
Your
I get it.
conversation, but I think
Then I'll
I
get
think
to the
we
point
need
if
to-
I may. Thank you. Then what I would say then is there is not a need for emergency funding. We've kind of gone around the legislative intent and not taken the employees as ours. Instead, we're transferring money to the DA Martin so she can pay all her employees and overhead expenses through September. Now, if there's a need for money for attorneys, then all DA Martin and I have to do is agree on how that's to be done. There's not a lack of funding, there's a lack of cooperation.
Thank you, Mr. Porter. Ms. Knox, thank you. DA Martin, thank you. With that, at this point in time, I think it's appropriate for the committee to either comments or questions for any one of the three that you feel that you would like to ask questions for. So, do you have anything further, Steph?
Mr. Chair, members, no, I think, the summary of the memorandum of understanding was provided, that there is funding through the end of September, although it is not for contract attorneys, it's for the 20 support staff, and expenses, if I'm understanding correctly. So that is what the MOU states. There was some financial information provided by Ms. Cox, that I provided to the board members, provide an estimate of monthly expenditures, just so we have some numbers on paper. But beyond that, I believe that the summary of where, of the documents that were provided and the MOU had been provided, but of course, staff are available for any questions that you might have as well.
Well, I will say one thing that I'm grateful that a tentative agreement has been reached by the parties that they can at least talk with each other. I'm hoping that that can continue so that there is a complete resolution to the issue. Not sure that you're going to get there, but if you continue to work together, it seems that you may be able to do that. So having said that, let's go to questions or comments by committee members. Member Montoya.
I guess my first question is, why is September 20 something the date of the termination of this agreement?
Who's the question addressed to?
I guess anybody who will answer.
Sure, I will, Chair and members of the board. That is the end of the first fiscal quarter. Since the fiscal year started July 1st, that's the end of the first fiscal quarter. So we just did it through the end of the first fiscal quarter.
Mr. Chairman, why would it not be done for the full fiscal year, being that the 3.8 million is available?
Mr. Chair, members of the board, with the way the employees are categorized under the DA personnel policy and the way the DA's offices are structured, you cannot just move employees over. It requires approval from the DA board, approval through DFA, and a lot of that sort of back-end office work. Since the two DAs are technically different agencies per constitution and statute, you cannot just shift them over. So it would allow time for them to be shifted over in order to effectuate the payment directly out of Division I funds for accounting purposes on the DFA coding and through the procurement code, which I'm sure you all are intimately familiar with. But that's why we did that, so that that time could be done, but they would still get paid through the end of this quarter while that paperwork and those adjustments were made between the two agencies for staff and the monthly expenses.
So, Mr. Chairman, are you saying that the employees will now, after the first quarter, be under San Juan County divisions?
That's the part that we still need to negotiate.
So, Mr. Chair, members of the board, that would require DFA approval and the DFA, approval for all of that coding purposes and the budgetary system. And then also the DA personnel board would have to approve that. So those are the two pieces that would have to be done in the next roughly 6 weeks.
Mr. Chairman, I would ask, if it's okay to ask Secretary Cox if they would even be okay with something like that.
Well, Mr. Chairman, members of the board, if the parties are in agreement, we are prepared to effectuate that agreement. If they're not in agreement, we're not prepared to effectuate a non-agreement. So it's up to them to fix this. GFA cannot fix this for them. Just like this board, not fix this situation. So
So, Mr. Chairman, it's my understanding that there is a different process that's happening on the court side. There's a different process that's happening with the Department of Justice in which someone has asked for an investigation or for impeachment. And then there's a different process about funding. Whether or not the district attorney gets impeached or not, the funding still needs to be in McKinley County. The big issue for me is not about Miss Martin, with no disrespect to you. It's about, or to Mr. Fortner, because they put Mr. Fortner in a bad situation. This has nothing to do with him. This is an elected office that didn't get their funding. And I'm struggling with this because of the fact that as elected officers, when we get elected by the people, whether or not we agree with the people or we do agree with them, they voted, they made a choice. And whatever that choice is that they made, we're supposed to have the funding to give them the constitutional duties that they're required to uphold. Well, now, whether they uphold them or not is a different process, and that deals with impeachment processes. But whether they get impeached or not, somebody needs to be in that office to be able to handle the job duties for the people that they serve. And when I'm talking about the people that they're serving, I find it disgusting. I don't know how to say it any lighter, that you have a county that's a colleague having oversight of a different office when they're very differently structured. One is very red, one is very blue. It's also disturbing that it's the most Navajo-driven population. And so I don't think that we would take away funding or have a problem giving funding to the Bernalillo County District Attorney's Office. But it seems like because it's San Juan County and it's far away and it's Navajo, it's a different suggestion of rules. And it's troubling because if the legislature doesn't like the Secretary of State for however she decides to do something with her office, are they gonna end up taking away her funding and giving it to me? How are we as elected officials supposed to go to the legislature and represent the people that we serve and the duties that we're supposed to constitutionally safeguard if we're gonna be afraid that we're not gonna receive our funding? I feel like the legislature completely overstepped their authority by not giving an elected official their funding. And I still stand firm that the precedents that would be put forth by not giving funding could be detrimental to every other elected office in the future. And so for our role as the Board of Finance, I would ask that we fund them at least until January, when the legislature can meet and give the rest of the year's funding. But it isn't, if it was my elected office, I would not be okay with my employees being transferred over to another elected office in another county. I just think that that's not appropriate. And to not have the resources to get the lawyers that you need is problematic, because I'm thinking about the kids who have been molested and raped, or the domestic violence issues that have come before their cases. Whether they're doing their cases or not, that's for the impeachment proceedings. But for the part of the funding to serve the people in McKinley or in McKinley County, that's our part that I think we can do. And so I still stand firm on the idea of giving funding. And there was one other comment that's troubled me for the last couple of weeks about we're starting a new precedence. We're not starting a new precedence. The new precedence was started when one elected office didn't get funding at all. If they came to us to ask for 2 new employees that the legislature didn't give them, then yes, we would be overstepping the legislature. But we gave the Secretary of State funding because they overspent. We've given other offices funding when they've overspent or not had it, or there was an emergency. So I can't understand how this is not an emergency when there's so many victims that are now being victimized by politics. Thank you, Mr. Chairman, for the time.
Thank you. Member Montoya, Member Cassidy.
Thank you, Mr. Chair. First of all, I want to congratulate DA Martin, DA Jack Fortner for getting together and completing the mediation that we had asked for. It avoided the need for this board to consider the need to fund, for the first 2 months of the fiscal year. Just want to remind everybody that the legislature gives us only a small $4 million to deal with emergencies throughout the state. and we are in the first part of the fiscal year. Every year, we have used that emergency money for legitimate emergencies, unlike what this is, because the money has actually been appropriated by the legislature. Unfortunately, it was a very messy process that has been referred to already this morning, and by Treasurer Montoya. It is very frustrating to deal with this, the way this has been thrown in our laps, when it really shouldn't be thrown in our laps. My view is, the legislature appropriates money. If we do this, we're reappropriating money that's already been appropriated. We have to find a way, for DA Martin and DA, Jack Fortner to figure out how to make this, acceptable, so that we're not reappropriating money that we're gonna need for something else in the future. It's gone when we do that. We can't get it back. And as far as Treasurer Montoya's comment about, appropriating money through December, it's really gonna need to be through the effective date of legislation that would be adopted by the legislature with the session ending in mid-February, third week in February. So it'd really be like 8 months, another 6-7 months. So a substantial amount of our emergency money would be spent on this, and it would, the form of mediation that's already been agreed to, hopefully can continue to move forward in an acceptable way to DA Martin. I understand Treasurer Montoya's points, and I really commiserate with that point of view. This is messy. Let's stop it. We need to figure out how to stop it. It's just not fair to the parties involved. And so I still stand the point of figuring out how to let the mediation process to continue to move forward. I really reflect on the fact that the citizens of McKinley County are being put in a tough spot. It's a shame what's happening here. We have so many other crises in the state of New Mexico. Why do we have this crisis when we don't need it? Thank you, Mr. Chair.
Thank you, Member Castle. Member Lehman.
A couple quick questions. Are the two of you still willing to keep going through the mediation process?
Yes.
Yes.
Mr. Chairman.
Member Montoya.
When I read the document last night, I think we received it pretty late in the evening. It sounded to me like one elected official is allowing their authority to be removed in order to get the funding. And I would say if the tables were turned, how confident would you be that you would give your authority for the San Juan County residents to McKinley County,
You want me to answer it?
if you'd like?
I will tell you that if it happened in my office and she got the funding, I would go to her and say, look, let's figure out a way to make this work so that it doesn't happen again next year. I'll work with you. Tell me how I can improve. Tell me what I need to do differently so that Senator Munoz and the legislature, it doesn't happen again.
I think for me, Mr. Chairman, my bigger concern is the sanctity and the sacredness of democracy and respecting people's votes and being able to have different responsibilities for each authority. The legislature's authority is to give the funding for you to complete and fulfill your constitutional duties. There's no way that you can fulfill your constitutional duties and set up for success when you're only getting the money that is from your statutory salary income. And so if we're going to send them back for mediation, which I also think is not in our authority to do because there's no contingency because we didn't give them any money for a contingency to do that. We're just setting up the residents for failure and the employees. So, Mr. Chairman, based on the employee situation, if someone decided to quit, they have so many hours that they get paid out. Are you able to pay them out right now? That's for your area. If an employee quits today and they have 200
And I have
hours,
200 hours.
are you able to pay them out?
I have absolutely access to no money.
Mr. Chairman, if you have insurance benefits for your 20 employees, are you able to pay their insurance benefits?
Not.
Mr. Chairman, for the people who are going through their court cases, the way doctors have an oath of office, I think this is for the lawyer. Do you guys have some type of oath that says you have to do the case, or do you guys just say, we don't have money, so we're not gonna do your case no more?
Mr. Chair and board members, we do have a code of ethics, which is why I have had to continue to work. I am not allowed to withdraw from any of the cases that were assigned to me prior to July 1st. I had to stay on and prosecute those. I have not been paid for that. It's also, I have a contract with Ms. Martin's office that was obtained under an RFP from a previous year. I cannot just get out of that. I did discuss with my malpractice carrier some of those concerns because that is a big deal. Working for free is something not many people do, but because the money is there and it has not been released to be paid to contract attorneys, even with this, this MOU here, you can see that it's restrictive on what contractors are able to get even at this point. So although it should be a nice small step in that direction, I am contractually bound and ethically bound by my rules to continue prosecuting the cases I've been assigned to. So I cannot just withdraw. That's not something that we are able to do.
Mr. Chairman, the budget says that money is going to the 200 category. Was the agreement also that money would go to the 300, meaning contracts, and 400 miscellaneous? Is there money going into those two?
I believe, Mr. Chair, board members, I believe that attachment is what was to the MOU. So it would go through September 26th. So that would cover some of those invoices. However, the language in the MOU does not cover matters that have been provided to me under my contract after July 1st. So it is a partial payment for myself and the other contract prosecutor, but only through September 26th. I have trials, just so you have kind of a context, I have trials that include murders and rapes booked out through March of 2026. So, and those are cases I had prior to July 1st. So you can figure out the conundrum that I am in. But there should be compensation for those portions up through September 26th with those caveats in the MOU.
And Mr. Chairman, to clarify, the contracted lawyers making $150 an hour, is that all going to be paid for up to September 26th?
Mr. Chair, board members, that will exclude cases that were assigned under my previous contract after July 1st. So it will only be a portion of the payment that would be made to myself or the other contractor.
So, Mr. Chairman, if you don't get funding today, we're basically saying that part of the work that you and the other lawyer have done is for free.
Mr. Chair, board members, yes.
And Mr. Chairman, if I heard you correctly, you're saying your guys' ethical oath says that you can't just stop working a case. You have to keep working the case.
Mr. Chair, board members, yes. These cases, not only were they assigned prior to this situation developing back in March, but this is also, I am the attorney that has handled it from the start. So all the details with trial prep, working with victims, working with witnesses, that has all been unique to me. And Mr. Vigil, the other contract prosecutor. So it's not something we can just necessarily hand off easily.
Thank you, Member Montoya. Member Kessler.
Mr. Chair, follow up to Fraser's comments there. And the question is both DAs, can this be resolved with mediation so that you can get that particular issue with regard to paying contract attorneys for cases not only prior fiscal year, but this fiscal year? What's the challenges? What are the obstacles for getting that done through mediation?
The answer is it can be done through mediation. I believe we made significant progress from where we were at the time of your last meeting and where we are now by agreeing to make certain payments through the end of the first quarter of the fiscal year. Part of that agreement is that we would pay the contract attorneys that were agreed to before July 1st, and that will continue, including the cases that Ms. Cox referred to. Now, it's the cases after July 1st that are the issue. Because when we were given that funding, then for us to pay, it would have to have been done through the RFP. And since DA Martin gave those cases to Ms. Cox without consulting us, without talking to us, I believe that's in violation of the procurement code. So we have to figure out with DFA, how do we pay those to not be in violation of, so that we won't, DA Fortner in our office won't be in violation of the procurement code.
And Mr. Chair, board members, if I could just follow up on that, because of the way the appropriation was done back in March, there are some challenges with RFPs from one agency being issued for another. The Secretary of Health cannot issue an RFP for the Secretary of Public Safety. That's just not how it gets done. Even though they're both executive agencies, DAs are quasi judicial, they're both there, they just can't do that sort of issuance, that sort of thing. So that's part of the challenge, is making sure that the RFP not only is properly issued and gone through, but then through any, if it's, you know, monthly intergovernmental MOUs like you see here, that have to be done. But there's a lot of logistics that we just can't do. The other thing, if I may digress momentarily to what Madam Treasurer mentioned earlier about the voters. In 1993, the state of New Mexico did reach a settlement agreement with voters in McKinley County and San Juan County that specifically addressed the separate elections of district attorneys, magistrate, and district court judges. And so there are a lot of legal issues with this overstepping and crossover between these two agencies that has been litigated back in the 90s. And there was a settlement agreement reached around 1993 that specifically set up the two separate DA's offices and allowed them to be responsible to their counties, specifically run their counties and do what's being done in there. So some of these legal issues are now potentially in violation of that previous settlement agreement, which was set up to honor the votes of the two different constituencies that Madam Treasurer mentioned.
Anything further?
No, Mr. Boardman, Mr. Chair.
That's
Sorry.
okay.
So many titles, I apologize.
Member Lujan, do you have anything?
Something off of Member Cassidy's question. It sounds like DA Fortner, are you more of the fiscal agent because the money was put in yours on accident or purpose, whatever it was?
But it wasn't an accident. Okay.
Okay,
I think Senator Munoz was the emphasis behind it and voted on. And so the answer is, I think I am a fiscal agent and also have a duty to follow the legislative directive. And would I like to be able to just to say, here's the money? But I think, number one, that would be in violation of what the legislature, the governor intended when they signed it. And number two, I don't think that I would curry any favor with Senator Munoz if I, in fact, went against what their intent was. And the intent was for us to work together.
so Mr. Chairman, legislative directive. I didn't read anything that said what the legislative directive was. Can you educate me on that?
Sure. So I don't have House Bill 2 in front of me, but the funding was given in two separate, our funding, Division 1, and then Division 2 funding specifically given to Division 1 to operate and to their employees were actually to have become our employees. I don't like that, but that's the way it was written. And so I think to do otherwise would go against intent. I mean, even the MOU that we did is somewhat contrary to what I think House Bill 2 intended, because those employees were supposed to become employees of Division 1. And that didn't happen, but we worked an agreement. And I think we can still perhaps work out some agreement on how to do the funding for the rest of the year and figure out how to fund the attorneys.
So, Mr. Chairman, does that agreement include you picking the attorneys or the other DA picking the attorneys?
Well, that's a good question. It would be pretty good if we could work together and do that.
But let's say, for example, I'm just thinking of, let's say, for example, the sheriffs. You have Bernalillo County Sheriff, very different values than someone that's a sheriff in the South. If the South is in charge of how they go about the funding and what they use it for, let's say they agreed to, I don't know, arrest immigrants and indigenous people, and he doesn't want to do that, so he says no, but the funding is with him, then that causes a conflict. On your end, if you decide you want certain attorneys and she wants certain attorneys, and it's her district that she should know, then that causes a conflict.
Right. We haven't even gotten to that part yet. And so what I'm telling you is that I hope that we can reach an agreement on what attorneys. There aren't any attorneys in Gallup that want to work there except one. And that person is kind of waiting for us to decide. We had reached an agreement with him to actually be in the office. At this point, he's not prepared to go work there. And I don't think Dave Martin wants him in her office either. So that's just some of the terms that we're gonna have to come to.
So, Mr. Chairman, overall on this contract negotiation, there's a fiscal agent portion and then there's an authority and oversight portion. It sounds like you're under the impression that the legislature wants you to have oversight of the McKinley County DA's office.
I guess that's a good question. I don't think of it as oversight. Instead, I think of it as cooperation and working together.
So, Mr. Chairman, if I took over your employees, would that still be cooperation?
Could be, sure. If you wanted to and you would come and manage them and handle it, I'd say good for you. I'm gonna put my effort in some else, another part of my office. I mean, the idea though is for us to work together.
Mr. Chairman, I just have a little bit of conflict with the hesitation of this shouldn't even be on your lap.
I agree.
Because you didn't request it,
I agree.
but for any elected office to have oversight of another elected office is a really slippery slope. And we've asked them to go into negotiations and they're here today and still haven't completed the negotiations. And at the end of it all, if the legislature gave it by purpose or accident or whatever the case, I think it's inappropriate for the funding from any one elected office to go to another elected office because it's almost like superseding the legislature's intent of the funding for the original purposes. So it's something to think about.
Madam Chair, may I just provide a little bit of this? Mr. Chairman, may I please provide a little additional information to Madam Treasurer's comments? Because I do have House Bill 2 and some additional information for context with some of the things she asked.
Let me just start by saying this. We've gone a long time now talking about this. And my position hasn't changed much either. I don't like the fact that we brought politics into this and talking about a blue county and a red county. I don't think that's appropriate. I don't think racial issues should be involved in this because that's not the point of what we're here for. I really don't believe that's what we're here for. We're here to make a decision as to whether or not this is an emergency and whether or not this emergency can be solved through other means. You ask about options that we have. Well, we have an option. The option is just to deny it without recommending any type of mediation and to just say, hey, that's your problem. We'll see y'all later. We don't need to be involved in this in any way, shape, or form. And I disagree with you when you say that we've done this before because we haven't done this before. We've never had this situation before the board, at least as long as I have been here. Maybe some other board has, this board has not. And it sets a precedent that any time an elected official feels aggrieved or needs something different, and this is different than the Secretary of State's situation, a lot different than that situation because of the conflict that has occurred. We've all tried to stay away from listening to the news media, but it's almost impossible to not listen to the news media and to listen to the last press conference that the two of you had, Ms. Cox and DA Martin. We saw that press conference. Didn't want to listen to it, turned it off as soon as I went past a certain point and just said, that's not it. That's not what we're doing here. That's not the situation. So what we've got to decide is whether or not this is an emergency under this situation. So to me, the emergency has kind of been resolved. It's a lesser type of an emergency. It is now a situation where both parties, in my opinion, and only my opinion, not the rest of the board, seem to be working toward an ultimate solution to this problem without the necessity of this board making that type of a decision. I believe, and I'll ask this question of Ms. Cox. Ms. Cox, is this lawsuit still presently before the courts?
It is, the one in Santa Fe seeks declaratory relief and injunctive relief, which, based on the directive from this board for mediation, that would have been a likely order from a state court as well to have done mediation to address these issues.
Okay.
There have been several parties dismissed, because they were not part of the mediation, et cetera. And so, because of the mediation that this board ordered, that one, is still pending. My understanding, if we are able to reach any further position or agreement so that Ms. Martin maintains her authority and such as the elected official, then that will end up getting dismissed. But that one is just declaratory relief or adjunctive relief, which for those that are not lawyers is more to figure out how the kids will play in the sandbox, if you will. So what rules everybody will follow with respect to the funds and how this thing. So we have this temporary agreement through September 26th that you all have. And so it is still technically pending,
Okay.
Mr. Chair.
The other thing, let me just say about contract attorneys, knowing a little bit about contract attorneys. Been one long time ago. And I know at different times, BFA is slow on their payments, no offense. And they don't pay immediately. They wait months and months and months before that ever happens. Those attorneys are still practicing, and I talk about public defenders more so than assistant district attorneys who take those types of cases. One of the things I do know that if an attorney, in fact, wishes to withdraw from a case, they can in fact file a motion to withdraw, and then it's at the discretion of the judge to either allow it or not. That attorney would still get paid for the services they rendered during that period of time that they represented the state of New Mexico or the 11th Judicial District Attorney's Office. That would happen. And that's the case with you in the future. And I'm sure with the FA being represented here today, DA Martin here, DA Fortner here, that the issue about the procurement code can be resolved. I have a lot of faith in the 3 or the 4 of you to come to that sort of a resolution. It doesn't seem impossible. It just seems it needs to be tried and talked about in order to be able to get it done. That's the way I look at this. And again, Madam DA, I gotta tell you what, it's a tough job that you have. There is no ifs, ands, or buts about it. DA Fortner, the same in your position. And I know, Ms. Cox, you used to be a DA in the 13th Judicial District or an assistant district attorney in the 13th. So I know you, I know of your reputation, and I know you're a good lawyer. I know you're a good assistant district attorney. Hard work, takes a lot of effort. You care about those people that you represent. You care about the cases that are before the court. You want justice for victims, absolutely 100%, and they deserve justice. But this needs, that to me means why the 2 of you should work together immediately to sit down and get to the bottom of this and solve this problem. The fact that we could give you money doesn't solve the problem because it still exists. And the next legislative session, it's going to exist again. I can only presume or assume that that's what's going to happen. So to me, these side issues, the other things that have been thrown out today, that's not what we're here for. And it's a very difficult decision for us to decide this because there are the victims that we talk about and those employees that are important to running the system, just like public defenders are important to the judicial system. DAs are important to the judicial system because they make it work. Without them, judges can't do anything. So we appreciate your service. We appreciate how hard you worked and as well, Mr. Fortner, Ms. Cox. We know how hard it is. I just don't, and I still don't think that this is the prerogative of this board to do this type of a decision. I concur with my colleague, member Cassidy, in terms of reappropriating money. I just don't feel that's what we should be doing. It doesn't make sense to me. I appreciate you bringing it. Again, don't know why you brought it here. I mean, I just don't know other than, hey, I have to do something and we were the last option that you may have had. But for me, my position is still the same as it was the last time. And with all due respect to you and your position, I hope this is resolved. I wish that immediately when we walked out of this building, that the three of you would go sit in a room and sit down and say, hey, and there's plenty of rooms in this building available that would accommodate you to sit down and talk. But I think that's the position that I have on this board. So I thank you for your courtesies and your testimony today. Mr. Fortner, the same with you, Ms. Cox, thank you. That's all I have. If there are any other comments or questions by committee members, feel free at this point.
For a motion, Mr. Chair, whenever you're ready.
We are ready for a motion.
I'll explain myself after, but I would move we deny the request. And my explanation is, to the extent we continue to do this and move forward, I don't think the parties are gonna sit down and negotiate the really hard points to get this resolved. And the other point is the money is already appropriated by the legislature. And third point, we don't have emergency money for this kind of request when we know we have so many other emergency requests that will be coming forward. Every year, we get emergency requests that we cannot always meet because of the lack of legislative resources. That's my motion, Mr. Chair.
We have a second. Second by member Levon. Would you please call the roll?
Yes, member or treasurer Laura Montoya,
No, it's the vote.
member Joseph Lujan,
Yes.
member Paul Cassidy.
Yes.
Member Trevisani has exited the meeting, Mr. Chair. So, member Michael Sanchez.
Yes.
Motion passes.
Thank you. Explain your vote, member Montoya.
I've been on this board only for 3 years, and never once have we stopped giving funding for an emergency because of the sake or the fear of not having enough money for other emergencies. I get that the money is somewhere, but it's not in that elected office. And for that reason, it is an emergency for the victims, it is an emergency for the employees, and it is an emergency for the precedents that we're setting by not allowing any type of funding to at least get them through the mediation process. And I would also hope that no matter what it is that you guys do, that you are able to respect each other's elected authority vested by the people that you serve. That's all I have.
Thank you, member Montoya.
Thank you.
Any last comments by any of the three of you?
No, sir.
Mr. Chairman, board members, no, thank you for listening to us today.
Thank you. With that, anything further?
Mr. Chairman.
With that, the meeting is adjourned.